Welcome to this explainer. Usually when we think about criminal law, it seems pretty black and white. You do the crime, you do the time, right? Well, the Bharatiya Nyaya Sanhita of 2023 actually completely flips that standard logic right on its head. Today, we're unpacking some truly extraordinary exceptions where committing a prohibited act literally isn't a crime.
It sounds like the ultimate legal paradox, doesn't it? Like, when is breaking the law not a crime? Well, the justice system actually recognizes that we are all human. We make errors, we face impossible threats, and honestly, sometimes we have to act aggressively just to survive. Punishing people in those specific situations wouldn't just be unfair, it would totally defeat the moral purpose of the law itself. So here is our roadmap for today. We'll be looking at 1. The guilty mind, 2. Mistakes and accidents, 3. Absence of capacity, 4. Justified acts and consent, and finally, 5. The right of private defense.
All right, let's jump right into Section 1. The guilty mind.
Here's the foundational rule. Criminal law fundamentally targets the intent, not just the physical action you took. This is the absolute underlying principle that dictates whether a court is even going to consider your actions criminal in the first place. Basically, you need a guilty mind, which the legal world calls mens rea, paired with the act. Without that guilty intention, even an action that causes real harm might completely lack the foundation needed to hold someone criminally liable. The law is really seeking to punish malicious intent, not just unfortunate outcomes.
Moving right along to Section 2, mistakes and accidents. Look, we all make mistakes, but how exactly does the law differentiate between a clumsy accident and a deliberate criminal act? Well, under Sections 14 and 17 of the Samhita, you're actually protected if you act in good faith under a genuine misunderstanding. The classic textbook example. Imagine you're rushing out of a coffee shop and you grab a black umbrella from the stand, honestly believing it's yours. Turns out it's someone else's. Technically speaking, yes, you took their property, but because you acted under a genuine mistake of fact with zero criminal intention, the law entirely excuses it. Now, there is a massive and incredibly strict boundary here that we need to clarify. Getting the facts wrong, like that umbrella mix-up, can totally excuse you, provided you acted honestly and reasonably. But a mistake of law? That will generally not save you. You absolutely cannot stand before a judge and say, "Oops, I didn't know that was illegal." Ignorance of the law itself is almost never a valid defense. To see how wild this can get, you have to hear about the real-world case of State of Orissa v. Ram Bahadur Thapa. In this astonishing case, the accused acted under a mistaken belief regarding the actual existence of a ghost. Because he genuinely believed he was dealing with a supernatural entity at the time, the court actually applied the principles of mistake of fact. It just goes to show that if the factual misunderstanding is genuine and reasonable given the context, the law will step in to ensure fairness rather than just handing out blind punishment. Still looking at everyday occurrences, Section 33 introduces this really beautiful Latin maxim, de minimis non curat lex. This literally translates to, the law does not concern itself with trifles. Let's be real, the justice system is completely overwhelmed as it is. It simply doesn't have the time or resources to waste on insignificant technicalities or tiny little slights.
And because of this rule, everyday social frictions aren't going to end up in court. Think about it. A minor push while you're navigating a dense crowd, a slight accidental bump in a narrow hallway, or some insignificant inconvenience. If an ordinary, reasonable person wouldn't complain about it, the law isn't going to recognize it as a crime either. It's a very practical safeguard to save judicial time and prevent people from misusing criminal law over petty grievances. Okay, let's shift gears to Section 3, absence of capacity. This is where the law actually shows a lot of compassion. It recognizes human vulnerability and those specific situations where an individual inherently lacks the mental capacity to commit a crime. Sections 19 through 24, along with Section 32, break down these immunities. For instance, young children get absolute immunity because they simply lack the maturity to understand what they're doing. Similarly, if someone cannot understand the wrongfulness of their act due to an unsound mind, they are exempt. What about intoxication? Well, it's only a defense if it was totally involuntary and left the person completely incapable of understanding their conduct. And finally, under compulsion, if you are literally forced to commit an act under the immediate fear of instant death, the law recognizes your complete lack of free will in that terrible moment. But of course, to make sure these shields aren't just misused as convenient loopholes, the courts have set some incredibly strict boundaries. A landmark example here is Dayabhai Chhaganbhai Thakur v. State of Gujarat. In this case, the Supreme Court firmly laid down the principles of the insanity defense.
It makes absolutely sure that this protection is strictly reserved for those truly suffering from an unsound mind. It's a delicate balance, maintaining the moral basis of punishment while still protecting the most vulnerable. Let's move on to Section 4, Justified Acts and Consent.
Consent is an incredibly powerful defense under Sections 25 to 30. It heavily protects personal autonomy. But listen, the law demands that valid consent must be completely voluntary and intelligent. That defense instantly crumbles into dust if the consent was obtained through fear, misrepresentation, or fraud. Plus, it obviously cannot be given by someone incapable of understanding the consequences, like a person of unsound mind or a child. It always has to be a mutual, entirely voluntary agreement.
And it goes beyond just personal consent, too. Society really needs certain professionals to be able to act without the constant fear of prosecution, just to keep our systems functioning smoothly. Under Sections 15 and 16, judges passing orders or police officers executing warrants are completely shielded, as long as they act in good faith. Similarly, Section 31 protects good faith communications. That means professionals giving honest advice or necessary warnings without any malicious intent are protected, all in the name of preserving the public good.
And finally, we arrive at Section 5, the right of private defense.
Let's face it, the state can't always be there to protect you in real time, so the law grants you the right to defend yourself. But there is a very strict timeline here. This is definitely not a license for revenge. Your right to use reasonable force to protect your body or your property sparks to life the exact second a reasonable apprehension of danger appears. But just as importantly, that right vanishes the very moment you are safe and the danger ceases. The force used must always be necessary and proportionate.
Now, there is a serious gravity to specific situations where the law actually empowers you to use lethal force. Generally, as we said, you can't use excessive force. However, the right to cause death is permitted in some incredibly grave scenarios. If you are facing an assault that causes a reasonable apprehension of death, or if you are facing severe, immediate threats like rape, kidnapping, or robbery, the law allows you to use maximum force to protect yourself and neutralize that threat.
Balancing this extreme right to self-preservation without crossing the line into excessive violence or vigilantism is really tricky. That's exactly why the case of Darshan Singh v. State of Punjab is so vital. It serves as the definitive Supreme Court guide, comprehensively explaining both the extent and the strict limitations of the right of private defense. It ensures citizens aren't left helpless in terrifying situations, while also explicitly preventing the misuse of this incredibly formidable legal shield.
So, as we wrap up this explainer, we've seen how the Bharatiya Nyaya Sanhita accounts for honest mistakes, mental capacity, valid consent, and our innate human need for self-preservation. It really paints a picture of a legal system that strives for fairness, not just blind robotic punishment. But it does leave us with a pretty provocative thought to chew on. If the law so carefully protects human error and vulnerability, where exactly do we draw the line between an act of absolute justice and a convenient excuse? Thank you so much for exploring these fascinating exceptions with me today, and keep questioning the complex world around you.